Okay, let's see how this works. I hope this is going to happen reasonably well. I want to just kind of give you a walkthrough of the material in these two chapters. So I'm going to do this in, I hope, in 3 lectures, but we'll see. So, and we'll see if this works. Now, remember, you have to read the chapter. I am presuming that you were reading it, that you were paying attention to it, that you were noticing the court cases in it, and particularly the vocabulary in it. So this is just sort of, the lectures are here as reminders of that material and to kind of help contextualize it and put it together in your head, and here and there to add a few things that maybe your book doesn't make mention of. All right, so we're talking in this first chapter that you were to have finished reading, Civil Liberties, and this is what I'm going to do now is just basically review some things we've already talked about in class. Okay, generally speaking, civil liberties are those individual freedoms that government cannot abridge. That's not an absolute thing. As you know, that idea of that the government cannot abridge civil liberties, well, depends on what you mean by abridge, doesn't it? You have the right to freedom of religion, but that doesn't mean you can do everything you claim in the name of religion. You have the right to freedom of speech, but there are limits to that. In large measure, those limits have to do with the right and freedom of other people. As we've said, as I've mentioned to you before, and I'm sure you've heard before, Benjamin Franklin's famous statement that you have a right to swing your arm, but your right to swing your arm ends at the tip of my nose. So where your right to swing your fist begins to interfere with my right to not be hit, that's where government intervenes. And so, your right to freedom of speech, well, there's limits on it in that I have a right to not necessarily listen to what you have to say, and so on. So that idea of civil liberties is balanced against the need for order in society and the protection of everybody else's rights. We know, of course, that the Bill of Rights is the document that is there to protect civil liberties, added to the Constitution, as we recall, you should know from U.S. history, in response to the anti-federalists. The Federalists, you remember, was that party, for want of a better word, that was pushing for the ratification of the Constitution. The anti-federalists, who were afraid of a powerful central government, afraid of what it might do to individual rights that they had just fought a revolution to get. So Alexander Hamilton and the rest of them, John Jay and James Madison, had to promise the states that they would include the first act of the new Congress would be to pass 10 amendments to the U.S. Constitution. That included the amendments that we call the Bill of Rights. Okay. Note the 9th and 10th Amendments, however. Yes, as you should already know. 9th Amendment, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. What does that mean in simple English? It means just because a right isn't listed in the Constitution doesn't mean that you don't have it. The presumption is that you have rights. The presumption is that you have freedom. Oh yeah, and we're going to list a few of those in the Constitution to make extra sure that the government doesn't interfere with them. But just because a right or a freedom is not listed in the Constitution doesn't mean it doesn't exist. The most famous example of that, as we'll get to in a little bit, is the so-called right to privacy. There is no mention of a right to privacy anywhere in the U.S. Constitution. But as we'll see in a little while, in the 20th century, beginning actually with the first telephone wiretap cases, the Supreme Court said, no, there is in the Constitution a right to be left alone, which you can lose if you are alleged to be committing a crime. But that's an unenumerated right. 10th Amendment. The power is not delegated to the United States, meaning the federal government, by the Constitution, nor prohibited by it to the states, are reserved to the states or to the people. In other words, if there is power, if there is authority, it can be given to the federal government by the Constitution. The federal government does not have power, oh yeah, and we the people limit it a little bit with the Constitution. The federal government has zero power, except what we explicitly give to it in the Constitution. You see the difference? The presumption is not that the federal government has the authority. The presumption is the federal government does not have authority unless it's given to it by the Constitution. If it's not given to the federal government by the Constitution, then that power is retained by the states or the people. If a power is explicitly prohibited to the states, then it must stay with the people. So Congress does not have explicit authority to regulate education. But the states, there's nothing in the Constitution that says the states can't, and therefore that power is reserved to the states or to the people. That's up to the people or the people of each state to decide. Those amendments are important because it establishes the principle that civil liberties are not restricted to those explicitly mentioned in the Constitution, and that power, the federal government's power, exists only by explicit grant. And if it doesn't have that power stays with the people themselves as the people of the United States, or they stay with the state government if the people have delegated it to the state government. Constitution, however, can prohibit a power to the state, and we'll talk about that in just a minute. Notice also the 5th and 14th Amendments, which protect due process. Now, 14th Amendment says specifically no state. 14th Amendment says several things, as you know from reading it, but specifically says, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny any person within its jurisdiction the equal protection of the laws. So this is the so-called Equal Protection Clause as well. All right, so why does this matter for civil liberties? Remember, a state has whatever power is not given to the federal government unless the Constitution prohibits that power also to the states. Well, the state is prohibited from abridging the privileges or immunities of citizens of the United States. Therefore, a state cannot deprive a person of life, of liberty, or of their property without due process of law, nor can they deny any person equal protection. So they cannot discriminate between citizens. There is no such thing as first, second, and third class citizenship. All citizens are equal, and if you're a citizen of the United States, your liberties, your civil liberties, are protected not just by, are protected by the federal government. They have a right to stop a state from interfering with your privileges and immunity that you have as a citizen of the U.S. So if it says in the Constitution you have a civil liberty, a state cannot interfere with that privilege that you have as a citizen of the United States. Hence, we have these terms, substantive due process. and I just make the point here, I forget if I made it in class, but you've read about it, versus procedural due process. Procedural due process is legal procedure. That is to say that if you are arrested for a crime, the cop has to bring you before a properly constituted court of justice. The judge has to provide you with an attorney. We'll see all those in some of the cases that come along later. You have to be given an opportunity to confront the witnesses against you. You can put up a defense, et cetera, et cetera. All those procedures that we follow protect your right to be innocent until proven guilty, etc. Substantive due process is a more theoretical, I shouldn't say theoretical, but it's a wider idea. Substantive due process refers to the right you have to have your civil liberties protected, particularly if you are in a minority. And I'm not talking about an ethnic minority, I mean any kind of minority. So if people who espouse a popular idea tend not to need the protection of the law because everybody's going along with it. It's the guy who espouses an unpopular idea or a guy who belongs to the smaller group in a particular state that needs to have substantive due process, that is to have equality before the law. So the federal courts are there to guarantee substantive due process, which protects all citizens from policies or laws which are unjust. And I guess if you're looking to put down a definition of substantive due process, that's as good as any. Substantive due process is the courts using the 5th and 14th Amendments, due process clauses, to protect citizens from unjust state and federal laws, as opposed to procedural due process, which refers to the protections you have in the procedures of court cases to protect your rights. Okay, all of this also gets us to what we talked about in class, which is the incorporation doctrine. That is, because of the due process clause of the 14th Amendment, equal protection of the laws, and that no state can abridge the privileges or immunities of someone who is a citizen of the United States. Your rights as a citizen of the U.S. have to also be recognized and protected by the state of New York. State and local governments have to guarantee those fundamental rights. That's the incorporation doctrine. Selective incorporation, therefore, is the judicial principle of the courts, that most protections found in the Bill of Rights are applicable to the states through that 14th Amendment. In other words, selective incorporation, the doctrine, as we call it, of selective incorporation, means that states cannot abridge, cannot infringe upon fundamental freedoms. Fundamental freedoms are those that are essential to order, to liberty, and to justice. So not every single item may be covered by that, but the fundamental ones, freedom of speech, freedom of the press, freedom of assembly, and so on, are covered. It is the federal government's obligation, and therefore the federal court's obligation, to protect citizens from the states trying to take those rights away, in addition to protecting them from the federal government infringing on them. I hope we all get that now. The case that you need to know for this is Gitlow versus New York. It's a 1925 case. Mentioned in your books. We talked about it in class briefly. I know all of this should be reviewed. Gitlow was a freedom of speech case in which the federal court, the Supreme Court, stepped in and said that New York does not have the right to infringe upon Gitlow's freedom of speech. Gitlow was advocating, unpopular things and criticism of the government and so on. New York State had defined that as sedition. Gitlow had taken it to court, and in 1925 the court found that the federal government has an obligation to protect Gitlow's freedom of speech from being limited by the state of New York. I should point out, as we did in class, if you remember, 1925. So it's almost 150 years after the Constitution was written. It takes us that long to have our first real case about selective incorporation. Gitlow is considered the first and landmark case whereby the federal courts assert that right. Okay, now I'm just going to roll through this. We did this in class. We talked about First Amendment cases. We start with freedom of religion, the non-establishment clause. Engel v. Vitale, we talked about. It struck down prayer in schools on the grounds that even a non-denominational prayer, as it is school-sponsored, is establishing religion. So Engel v. Vitale, you are, again, you're familiar with that one, where the federal government says we have the right to protect people's freedom to believe or not to believe, to be atheist if they want. And that when a government agency, like a public school, even if it's non-denominational, it doesn't favor one religion over another. The fact that it's favoring, if you will, religiosity at all constitutes something that's too close to establishing religion. Lemon v. Kurtzman, we also talked about in class. It's a 1971 case that established the case, you remember, guys, was about money that was being used for parochial schools, Catholic schools. Lemon v. Kurtzman, there are two Lemon v. Kurtzman cases, but the one we're interested in is the 1971 one. And the Supreme Court said that it's not establishing religion if the government gives money to a religious school, as long as the money has a clear secular purpose, that is a non-religious purpose. The money is not used to advance religion or to inhibit it, to favor one over another, to discriminate against one. And it does not foster excessive entanglement. That is, the government can give the money and not get too involved with things. So as you recall, we talked about in class, you guys get New York State textbooks. The textbooks for many of your classes, the ones that you don't buy, for instance, the textbook for this class, is bought with money from the state of New York. Farrell gets a kind of budget from the state. We can use the money to buy textbooks, but it can't be used for religious books. It has to be used for books that fulfill a state secular education requirement. So you have to take math, you have to take history, etc. You can buy a secular textbook for that. There's a secular purpose because you would be taking these courses in a public school anyway. It doesn't advance or inhibit religion, so it's not being used to promote the particular religious mission of the school. And it doesn't foster excessive entanglement. There were attempts to set up systems whereby they paid teachers a salaries. Remember, we talked about this in class. So, I would be getting a salary for 7 periods a day from New York State, and then the 8th period I would suddenly become a religious teacher. And the Supreme Court found in other cases, no, that's no good, because the state becomes too involved then with, payroll for teachers and hiring teachers and all that. As long as the state is staying arm's length from the religious institutions, this is okay. Similarly, for things like buses, the grammar schools can get the yellow buses, which are subsidized by the government, because there's a secular purpose. You're safely transporting kids to and from school. It doesn't have anything to do with the religious mission of the school. And they make a contract with the bus company. The bus company sets up routes. The government is not really getting involved with, it is not entangled with the school. Okay, in addition to the non-establishment clause, we also talked about the free exercise clause. That is, the government cannot interfere with people freely exercising their religion. And I'm going to run through most of these, but there's 2 that we didn't talk about in class I thought I'd throw in. Reynolds v. U.S., which is the polygamy case with the Mormons. And if you remember that one, basically you're free to believe whatever you want, but that doesn't mean you can always do it. And the government has a law against having more than one wife. It was found that you can advocate other beliefs, you can believe other things, but you cannot act on all of them. Oregon v. Smith, that was the unemployment case, if you remember. There was Department of Employment. It was the guys who were denied unemployment benefits because they had been fired for using drugs, which they claimed was part of their religious practice. And the Supreme Court found that you can believe what you want, you can advocate what you want, but the state, if it has a valid law to restrict the use of hallucinogenic drugs, you don't get out of that law simply by claiming a religious exemption. Which then you get into, now, the law is messy, guys. It's not always clear, because that case was followed up by Gonzalez v. Ocentro, which we talked about, saying that the use of a mind-altering substance, use of drugs by a religious group, is part of free exercise, and as long as the government doesn't have a compelling interest in restricting its use, and, we're talking in the limited situation of a religious ceremony. This was a particular, it was peyote, I believe, mescaline, which, was used within the context of a sort of religious prophecy kind of ceremony, and not out on the streets and so on. The government had no compelling interest in getting involved in that. So, Ruth Bader Ginsburg pointed out that Gonzalez and Smith are inconsistent cases. And it's a little hard to see how they fit together. Now, to make things even more complicated, I'm going to give you 2 more cases now. So this is new stuff, so take notes. The Gonzalez case involved, as we talked about, the RFRA, as it's sometimes called, the Religious Freedom Restoration Act. Religious Freedom Restoration Act was a law Congress passed in 1993 that was actually introduced by Charles Schumer, who's a rather liberal Democrat from New York. But it was supported by a lot of conservatives. The Religious Freedom Restoration Act was Congress restricting governments from interfering with religious practice. It was a movement at the time that, governments had gone too far in getting, in restricting religious practice. So RFRA was put in. And in Gonzales, the federal government found that RFRA is grounds, this congressional law is grounds to overrule a state restriction on religious drug use. There's no compelling government interest, and the Congress had made a law to protect what in theory were First Amendment rights. Therefore, it was Congress protecting people from religious oppression by their state. Okay. And yet, the Supreme Court also took another case, the City of Berne versus Flores. And Berne there, by the way, is correctly spelled, B-O-E-R-N-E. This was a case in New Mexico. And just briefly, again, all of these cases, by the way, guys, you can always look up on that OYEZ, OYEZ.com website. This is what the case was, basically. The Catholic Archdiocese of Santa Fe wanted to expand a church, wanted to build a new church building. The government of the city of Berne stopped them, purely on the grounds of zoning. They said that the neighborhood in question had been zoned a special historic district, meaning that you weren't allowed to build new buildings there or substantially change the look of the existing buildings, because it was basically a tourist attraction. They wanted to keep this part of downtown Berne looking like it did in whatever the late 1800s. We have similar things in New York. We have landmarking of buildings, and we have historic districts. The idea is to preserve the history of the area. So if you owned one of the buildings, you could restore it, you could fix it up, but you couldn't change it. And the Catholic Church wanted to build basically a new building in this district. And the city of Berne said, no, you can't use the property for that. So the Archdiocese of Santa Fe took the city of Berne to court. It wound up in the claiming that the city of Berne's restrictions violated the Religious Freedom Restoration Act by interfering with the freedom of the Catholic Church to use its property the way it saw fit, including to build a new church. Supreme Court took the case and actually overruled the Religious Freedom Restoration Act, declared at least parts of it unconstitutional. It's still not clear how constitutional the whole Religious Freedom Restoration Act is, but it declared that it was unconstitutional when Congress was managing local governments, where their local laws are not favoring one religion over another, or are overly restrict religious practice. In other words, Congress can protect the freedom of exercise of religion, but they can't expand that freedom. They can't make a law that makes that freedom larger than it is in the Constitution. The Supreme Court had found that zoning restrictions by local governments were constitutional, as long as those zoning restrictions don't favor one religion over another, or don't forbid religious practice altogether. You can make a law, for instance, saying, that your church building has to meet certain building codes for safety, that you have to have a fire suppression system in it, that for traffic reasons you have to have a certain number of parking spaces. You can make rules about that, they found, as long as it's not singling out, Catholics over Protestants or Protestants over Jews, and it's not making it impossible for you to practice religion within, the city of Bern here. They can make a zoning rule, and that Congress had overreached. So the Religious Freedom Restoration Act, the Supreme Court found, does not apply in this case. Congress had overstepped its authority in trying to expand what freedom of exercise in the First Amendment covers. Well, if you think it's complicated that on the one hand they're siding with RFRA and then they're voting against it, then you have another case using RFRA that comes to the court in which, again, they side with RFRA. This is the Burroughs versus Hobby Lobby case. This is a recent case. So, again, basic facts. Hobby Lobby is a privately owned chain of stores that sell, stuff for arts and crafts and hobbies and all that kind of stuff. And it's family owned. It's not publicly owned, as in they don't sell stock. It's owned by a family. And but it's big. It's a big chain of stores in other parts of the country. And the family is devout Christians. Okay, the Affordable Care Act, which is also called Obamacare, set certain requirements that if you're an employer who has more than 50 employees, I think it is, your health care plans have to include certain things. So when you offer health care plans to your employees, there are certain things you must cover in that health care plan. The idea being that a health care plan has to actually provide for the health of people. So you can't knock out the more expensive items just to save yourself money if you're going to offer them health insurance. The Affordable Care Act mandated that they supply, as part of their health care plan, coverage for contraception. The owners of Hobby Lobby argued that that was a restriction on their freedom of religion, because many types of contraception actually cause abortions. I hope that you've gotten that at some point in biology class or healthcare class, but this is the case. A lot of the pills and medications that women take as contraceptives, in fact, don't prevent a child from being conceived. They prevent the child who is conceived from remaining in the womb. So you are causing a very, 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 very early abortion. There are a lot of people, including the Catholic Church, that holds that that's the taking of a human life, that you're causing the death of a person. And so the Hobby Lobby owners said, we can't be responsible for providing to our employees a means by which, in our religious belief, they are killing human beings. In other words, they're saying the Affordable Care Act is forcing us to violate our religious conscience by providing the means for somebody to do something that we consider to be a heinous, awful sin of killing another human being. Notice the seriousness of this. This is not saying you're violating my conscience by making me do something I think is unwise, like providing health care for everybody, or you're violating my conscience by making me do something I don't like, or I don't think government should be involved in, or I think is a bad policy. That wouldn't be covered by this. They're saying that you are forcing me to do something which I consider to be in my religion. You are putting a gun to my head and forcing me to do something that in my religion is a serious sin. The Supreme Court found that the Religious Freedom Restoration Act that we talked about earlier, in fact, prevents Congress from putting a substantial burden on the practice of people's religion. And therefore, Congress had passed two self-contradictory laws. They had passed RFRA, which says that federal law cannot substantially burden a person's religious practice. And on the other hand, they had passed the Affordable Care Act, which said that you have to provide contraception. And so the Supreme Court found that when you have these two laws in conflict, RFRA counts. And so Congress had restricted itself. It had actually passed a law in violation of its own laws, and therefore the Supreme Court found Hobby Lobby could not be required to cover contraception in its health insurance that it offered employees. Okay, that's a recent case, and I thought you should be aware of it. Okay, let's then pick up next. Okay, now let's talk about, we talked about freedom of religion. Congress shall make no law with respect to establishing religion or prohibiting the free exercise thereof, or abridging the freedom of speech. Okay, so let's get to freedom of speech. When you're talking about freedom of speech, you've got three things: freedom of thought, freedom of words, and freedom of actions. The idea of free speech was, on a larger level, we call it free expression. And free expression means that you have to have ideas to express. So freedom of thought comes first. And there's a pretty much absolute principle that you can think whatever you want. The government has no right to interfere with that. And the government has never really tried to, although those of you who have read things like 1984, know that that's the thought police of 1984 are really not too much off the mark from what has happened in some other parts of the world. If you were caught showing any evidence of thinking other than the way the government wanted you to in Nazi Germany or in the old Soviet Union, you faced prosecution in Cambodia, in Maoist China. There really were restrictions on thought. Now, could they read your mind? Well, indirectly. If they saw any of your attitudes or your behaviors that did not sufficiently reflect the thoughts that they wanted you to have, you could go to a prison camp or a re-education camp or whatever, as they called it. So there have been governments in history that have tried to restrict thought, hard as that may be. In the United States, freedom of thought is pretty much sacred. Okay, so then the next step is words. Expressing those. Speaking them on a street corner, proclaiming them in front of a group, stating them on radio, on television, posting them on the internet, publishing them, as we'll see with freedom of the press. That comes a little bit later. And, all the modern methods of communication we have now. Words are protected by the Constitution. Speech, in the sense of what you say, is protected, although, unlike freedom of thought, there are limits to freedom of your words. And we'll see that in a second. And then finally, there are actions. Actions in terms of things like symbolic speech that we'll talk about in a second or two. Okay, the First Amendment protects pretty clearly against what's called prior restraint. Prior restraint means restraining somebody from saying something before they say it. The government cannot outlaw you, cannot stop you from saying something before you say it. Once you said it, then you may be held accountable for it. But they can't shut you up beforehand. That prior restraint doctrine refers not just to what you say, but what you publish. Freedom of the press says that if you publish, the government cannot restrain you prior to publishing something, but once you publish it, if it's a violation of the law somehow, then you can be held accountable. Okay, so let's take a bit about freedom of speech itself. It has a checkered history. It's not an absolute thing. The Alien Sedition Acts that you should know from U.S. history go back to John Adams. So that's our second president. The ink was barely dry on the Constitution and the Bill of Rights. And here's John Adams passing laws that prevented people from criticizing the government. Which, you know, I mean, it's the most ironic thing in the world, isn't it? Because it's John Adams had his name literally on a British hit list. You know, if the American Revolution had failed, the British were prepared to give pardons to an awful lot of Americans. John Adams was not. There was a specific list, and Adams was one of the people who, under any circumstances, was going to be hanged for criticizing the British government. And yet, he puts it in. The Alien Sedition Acts were terribly unpopular for obvious reasons. And they, in a way, they are a great failure in that the federal government has not tried really to restrain speech in that way again. Okay, well, even though the federal government backed off of restraining speech after the Adams administration, the states put in their own restrictions of various kinds. So states began to prosecute people for publishing articles, letters to the editor, essays that were critical of state government, even of the national government. And that actually happened throughout the 1800s. Your book, I believe, makes a point about slavery. In the northern states, just prior to the Civil War, publication of information about slavery that was positive, that was pro-slavery, was made illegal. You could be put in jail for publishing things that were in favor of slavery in the northern states during the Civil War. By the same token, in the southern states, there were laws against publishing anti-slavery tracts on the grounds that you would stir up the slaves and they could rebel and that was a danger to the public. It's not until the Gitlow case that we previously discussed a couple of times now in 1925 that the federal government establishes that doctrine of incorporation and steps into New York with that selective incorporation thing and says that freedom of speech and freedom of publication, freedom of the press, are fundamental rights that the federal government has an obligation to protect people from their own states trying to usurp. Okay. The two of the key freedom of speech cases to know are the two that are listed there. And I guess I should have put the dates. 1969 is Brandenburg. Okay, so the first one comes out of the Espionage Act. The Espionage Act of World War I made it illegal to engage in seditious speech that would be likely to harm the United States as it was trying to fight a war. The case there, which is sometimes referred to as Schenck versus the United States, I believe that the name is actually meant to be pronounced Skenk. No jokes. Ha. But that's actually how the name is pronounced, Skenk. Skenk versus the United States, 1919. You can see it gets to the Supreme Court just at the end of World War I. And again, you can read the details of it in your textbook or on that oyez, oyez.org site. The Supreme Court said that you have the right to say what you want unless your words present a clear and present danger that those words will bring about substantive evils. The clear and present danger test was the one that we lived with from 1919 until the 1960s. Your speech is protected by the First Amendment under the Schenck decision, unless those words are likely to create on the spot, or I shouldn't say, are likely to bring about the kind of substantive evils that the Congress was seeking to prevent by its legislation in things like the Espionage Act. You basically had to be advocating doing something specific, and there was a likelihood that people were going to act on your words to bring it about. In the Brandenburg v. Ohio case in 1969, that again is in your book, and you can read online, the court limited that further. They said that your words are protected unless they represent a, quote, direct incitement to, quote, imminent lawless action. So what are we talking about here? Well, in the Schenck case, the famous phrase that came out of the decision was that you can't yell fire in a crowded theater. You know, if you were out to falsely, you falsely shouted fire in a theater and you were likely to create panic that people would be trampled to death in, which was a real problem at the time. There were several cases of that, actually. Then your speech is not protected. Then your speech becomes harmful to people because there was a clear and present, that is, if you will, immediate danger that your words were going to bring about some substantive, factual problem, some evil. The change that's made with Brandenburg is that your words had to be intended and likely to stir people to a lawless action more or less on the spot. So if you were just simply saying, the draft stinks, remember 1969, you're in the middle of the Vietnam War, the draft stinks and nobody should go along with it. That speech is protected. if you stand there and say, everybody here, you should now, I want you all to take out your draft cards and I want you to burn them on the spot. Well, tampering with a draft card, burning a draft card, was considered destruction of government property. So you were directly inciting people to an imminent lawless action. That is not protected speech under Brandenburg. The direct incitement test is the one that we live with now at the moment. Okay, so what else is covered by First Amendment? Well, symbolic speech is covered by the First Amendment. Symbolic speech as in actions that you take. If you are expressing yourself, not just doing anything, getting into a car drunk and driving around is not symbolic speech, but engaging in some activity that is meant to communicate an idea, this is symbolic speech. So the two cases that you should know and be familiar with are first Tinker v. Des Moines, Iowa, that is, which was a case, 1969. Again, it's Vietnam War. Kid named Tinker went to school. It was a public school. Wearing a bunch of the kids were wearing black armbands as a protest against the war, and the school found that to be disorderly action. The Tinker case, the Supreme Court decided that the students wearing armbands is a form of expression that is protected under the First Amendment. Now, the Tinker case is a little bit complicated because they were students. This kid, Tinker, was 16 at the time. Students do not have the same degree of protected rights in school, because the school, for the safety of the students, and because they are underage and technically in the custody as parents, in loco parentis, in the place of parents, as we say in law, of the school officials, they don't quite have the same rights. But the Supreme Court found that that they're allowed to engage in free speech as long as it does not materially and substantially interfere with the operation of the school district. As far as students go, it's important. It's an important decision on that level. In a public school, students have the right to express themselves up to the point where they are materially and substantially interfering with the school. So, if they want to wear a button that says, that advocates or something, they're allowed to do that. In a private school, you don't have those rights, because in a private school, you've signed up voluntarily to be part of a private organization and to live by its rules, and if you don't like it, there's the door. But in a public school, your rights are more expanded. The larger issue out of Tinker v. Des Moines was the finding by the court that something like wearing an armband, which is a physical action, counts as freedom of speech because it is a form of pure expression. Texas v. Johnson was a case about flag burning. This fellow named Johnson burned an American flag as part of his protest. And there is a law in Texas against it. He was brought to court. He challenged it, wound up at the Supreme Court. And the Supreme Court found that basically, if the American flag means anything, it stands for freedom. And freedom of expression, even if that means expressing yourself by showing contempt for the American flag. And that the burning of the flag constituted a symbolic act. And as long as he wasn't setting anything else on fire and wasn't creating a danger to other people, that was a protected form of speech. I should also note that what else is protected under First Amendment? Well, as we've said, political speech. The Skank case, the Brandenburg case, the Tinker case, the Texas v. Johnson case, all of them are all about, even the Gitlow case, are all about criticism of the government. You can say whatever you want if you're criticizing the government, as we said, as long as you are not inciting people to imminent lawless action, or inciting them, which would be imminently lawless, inciting them to violence. What about speech between people? Hate speech. There are a lot of states that have tried to put in laws against hate speech, and the Supreme Court has found that hate speech is protected. It may not be pleasant to listen to, and you cannot force somebody to listen to it. You can't corner them and make them listen to your hatred. But it is as protected as other speech. So as long as you do not incite somebody to commit violence against another person, you can stand there and say unpleasant things about them. The case I'm giving you here, Snyder v. Phelps, I'm sure will not show up on the AP exam. It's not really in your books, but I just give it to you in case you want to read a case. This is Fred Phelps, the guy who has his own personal church that goes around and protests at all of the servicemen's funerals. God hates fags, as his sign goes. And the court found that as long as he's not interfering with somebody's right to have their funeral, and he's not blocking access to it or anything, if he wants to stand across the street with a big sign saying to the world how much he hates gay people or how much he hates America, he's entitled to do that. That is protected under the Constitution. There is a saying among many of those involved with First Amendment litigation that the best cure for poorly used First Amendment rights is better used First Amendment rights. That is, the cure for bad speech is good speech. So as much as he has the right to protest and say nasty things, other people have the right to ignore him. You don't have to listen to what he says, and he cannot legally force you to listen to it. And you can stand up and say the opposite. You can stand up and hold up a sign saying America is great or something, and fight speech with speech, if you like. Okay, we talked about what's protected. Let's talk now a little bit about what is not protected speech. First is what are called fighting words. Fighting words are not protected by the First Amendment. These are words, this is the definition, by their utterance, they inflict injury or tend to incite an immediate breach of the peace. So, in other words, fighting words, you're not simply expressing your opinion, you are saying something to somebody else where you know that you are starting a physical fight. So if you're sitting in a bar talking about how much you hate the Obama administration or how much you love the Obama administration, and people are upset by that, that's protected. But if you say, I think Obama stinks and I'm going to punch any man who says otherwise, knowing that the guy next to you has a big Obama button on, that becomes fighting words. You're trying to incite a breach of the peace, a fight. That's not protected by First Amendment. Also not protected is what is called obscenity. There's a lot of litigation about what counts as obscenity, but the basic principle is that, first of all, obscenity is not itself protected. The First Amendment is meant to express thought, particularly political thought. It's meant particularly to allow you to express your criticism of the government, but also to express your thoughts on other things. Obscenity is not protected basically because the Supreme Court has decided that obscenity does not have a redeeming social purpose, and therefore the government can restrict its dissemination. There are two cases that deal with obscenity. The older one, which is now obsolete, is the Roth case, Roth versus United States. And the second one is Miller v. California. Both of these cases came out of the mails, meaning the snail mail, the postal service. These guys had been sending brochures, flyers, catalogs selling obscene material through the postal system. And because the postal system is regulated by the federal government, it therefore is a federal case. The Postal Service said you cannot, there's a law, Congress passed a law saying you cannot send obscene material through the Postal Service. So Roth had done this, and so he was prosecuted, so Roth appealed the case. In the Roth decision in 1957, they said that Congress had the right to prevent the mails from being used for obscene speech. What counts as obscene speech? It has to be utterly without redeeming social importance. And you determined whether it was obscene by testing whether, to the average person, applying contemporary community standards, the dominant theme of the material taken as a whole appeals to the prurient interest. And prurient simply means appealing to, technically it means appealing to an excessive interest in sexual matters. That's what it's defined as. So the test was whether if you took the average guy from the community, if they looked at the material and said, yes, this material is really there simply to appeal to people's sexual interest, and it has no other social importance or social message, that counted as obscenity. There was a lot of litigation that went on, and in 1972, in Miller v. California, the court specified that a bit more, and this is the decision that still controls today. Miller v. California was a similar case. It was a guy who was sending out catalogs of material that was in violation of California's own obscenity statutes, and all the states have them. New York has it too. And the court refined its definition. It said, in order to tell whether something is obscene and therefore not protected by the First Amendment, it's got to pass this three-part test. Whether the average person applying contemporary community standards would find that the work, taken as a whole, appeals to the prurient interest. So you get your average man on the street, from your street, to look at the material and says, yes, this is really about appealing to sexual interest. Second, at the same time, the work must also depict or describe, in a patently offensive way, sexual conduct specifically defined by the applicable state law. So a state can define one particular sexual activity as obscene and not another. And C, at the same time, the work, taken as a whole, lacks serious literary, artistic, political, or scientific value. So, for instance, under the Roth decision, if you wrote a novel that was exploring, I don't know, mankind's search for meaning in the 20th century or something, and you had a bunch of scenes in the novel that were heavily sexual, that could be counted under Roth as obscene. Under Miller, if you could show that the work had literary or artistic value, if it had serious scientific value, if if it's a textbook on anatomy or on human reproduction couldn't come under the Miller case. There was a way out from under obscenity for works that under Roth had been declared obscene. There were a number of novels that had some pretty graphic passages in them. And this had gone on a bit. For those of you who are into English literature, I don't know if you are, one of the great works of the early 20th century is a work by James Joyce called Ulysses, which is a towering, monumental work of English literature. It has some racy bits in it that are not thrown in there simply to be racy, but they have symbolic meaning and all this. That was held up. That was not allowed to be sent through the mails in the United States. There was a big court case in order to allow it to be published here. In the 1940s and early 50s, you had the same thing. You had a number of novels that dealt with homosexual characters or dealt with rape that took place as part of the storyline that were deemed to be obscene. The Miller test, which is the test that we still work with today, if the work has a serious literary, artistic, political, or scientific point, even if there are parts of it that depict sexual activity, even sexual activity in an offensive way, it still would not be considered obscene. One of the problems, I will tell you, with the Miller test as it exists now is the problem of applying contemporary community standards. Back when Roth was decided, even when Miller was decided, there was some problem in defining what a community was. Did the community mean the neighborhood of Oakwood around Farrell? Did it mean Staten Island? Did it mean New York City? If you think about it, the standards of what people consider offensive, if you look at New York City as a whole, would be very different from what might be considered offensive on your particular block. If you go to an immigrant neighborhood of, conservative folks right off the boat from Italy or Ireland or, the Eastern Europe, they might consider some things racy and obscene that a typical teenager growing up in Manhattan might not. So where do you draw the line of community? The second step for that is now we live in the age of the internet. What counts as a community in the world of the internet? That's pretty hard to define. And we are still waiting for court cases to come along to decide whether and how those community standards apply. I guess I should just mention here, I don't think it's in your book, but Reno v. ACLU, which I guess I should put a date in, it's 1997, I think. The Reno v. ACLU case, ACLU, American Civil Liberties Union, Janet Reno was the Attorney General at the time, and when the internet really started booming to the point where it was the dominant form of communication, the Congress passed a law called the Communications Decency Act, which prohibited indecent material on the internet. The point of it was to try to prevent kids from getting their hands on pornography. The Supreme Court actually struck down that Communications Decency Act because they said, even though we don't want kids to get their hands on pornography, the way the law was written was too vague, too broad, and might have a, quote, chilling effect on people expressing themselves freely on the internet, because they were too afraid that they'd be prosecuted if there was anything on their website that, was not appropriate for a little kid to see, which was sort of what the Communications Decency Act was aimed at. And so that attempt to regulate the internet was struck down, and we really haven't had much of one since. Also not covered by the First Amendment, not protected, are libel and slander. So libel is printed defamation of somebody. That is, when you print something damaging against them, particularly something that is untrue. Slander is spoken defamation. So if I stand on the street corner and say that, Congressman Donovan is a convicted criminal, that's untrue. That would be slander. If I printed in a newspaper that Congressman Donovan is a convicted criminal, if I printed it, that becomes libel. Libel and slander are not protected by the First Amendment. You cannot go around lying about people and have that protected. The government cannot, again, engage in prior restraint. But once you print it, you can have your pants sewed off. The Times v. Sullivan case, which is the New York Times versus Sullivan, it's a 1964 case, refers not to individual private people, but it refers to public officials. And this is a very important distinction. Private people have a right to their good name, and if you print something about them that is untrue, they can sue you for that. No question. On the other hand, if you are a public official, the standard is this. If somebody prints or says something untrue about you, in order to sue them, you must show actual malice and knowledge that the statement was untrue. Actual malice means they must have chosen to say something untrue about you, knowing what they were doing was untrue, with an intention to harm you. So if a reporter writes something about you that is just a mistake, he honestly read a file and it says Dan Donovan and it says convicted of a felony, and he honestly believed that was the Dan Donovan who was the congressman, and he misunderstood and printed that. That's not something that they can sue you for. You have to show actual malice, an actual intent to harm the person, and knowledge that what you were saying was not true. Or you have to show a reckless disregard for the truth. That is, you have no idea whether it's true or not, but you went ahead and printed it anyway. That's a reckless disregard for the truth, particularly if it's something that could be easily verified. So some guy walks in the door of the newspaper office and says, I heard that Dan Donovan is a convicted felon. And you say, I'm going to print that on the front page. Is it true? Well, I don't know, but it makes a good story. That's reckless disregard for the truth. If a reporter or an individual private person or a candidate running against a public official makes a statement that they honestly believe is true and there can show some sort of good faith reason why they thought it was true, that they did try to check it, or they got it from what they thought was a reliable source or something, then you can say that and get away with it, because public officials it's to prevent the chilling effect. Yeah, if you didn't have this protection, then reporters would never print anything negative about a public official for fear that the public official would sue them because of any little thing they got wrong, or anything they got not quite 100% right, or simply sue them in order to sue them, even if they're going to lose the case, to cost them money and run the newspaper out of business. Thanks to the decision of Times v. Sullivan, public officials have a very difficult time suing people unless they can show that the news information, the media outlet, really recklessly didn't do their job to check their facts, or intended to harm the person and knew that what they were printing was false. Okay, that covers First Amendment. Next lecture, I'll try to get through the rest of the civil liberties, and hopefully this is helping you guys.